Hi there, my name is Maureen McCarthy, and I'm the current president of City Club's Board of Directors. Our mission is to inform, connect, and engage our community to strengthen the civic health of our region. We emphasize civil conversations and listening to others. For our October and November programs, we will be going back to our temporary standard format of meeting live via Zoom. Our program committee is finalizing the details regarding our topics and speakers, so please stay tuned. Before we begin, I want to say a huge thank you to our business sponsors. They are Larson Gross, Lummi Commercial Company, Danny Neal of the Mulliot Group, the Opportunity Council, Unity Care Northwest, Pacific Continental Realty, Village Books, Western Washington University, Whatcom Community College, and the Whatcom Community Foundation. And now, here's Tanya Baumgart, who will introduce today's speakers and moderate our program.
Thank you, Maureen, and welcome to the second of 3 candidate forums produced by Bellingham City Club. Today's forum features the candidates running for the Whatcom County Superior Court Judges seat, positions 2 and 4. Superior Court judges supervise the judicial business of the Superior Court. They act as the spokesperson for the court, direct the court administrator in implementing administrative and general court policy, and perform judicial and administrative duties as set forth in General Rule 29. Superior Court judges are paid $199,675 annually. Running against each other for position 2 are James Erb and Evan Jones. Would you like to raise your hands? Thank you. They're running against each other, position 2. James Erb is the Senior Assistant City Attorney for Bellingham, and Evan Jones is the Senior Deputy Prosecutor for the Whatcom County Prosecuting Attorney's Office. The 2 candidates that are vying for position 4 are David Freeman and James Nelson. David Freeman is currently the position 4 judge for Whatcom County Superior Court. James Nelson has worked as a private attorney for 31 years. Thank you all for joining us here today. Before we start, I will share the forum rules with you. For each question asked and for the closing statements, you will have 90 seconds to respond. If in the course of an answer, a candidate directly mentions an opponent, the opponent will have 30 seconds to respond. Our timers today are Susan Wright and Michelle Kopcha. Thank you for helping us here today. They will be operating the timer screen. So when a question is being timed, the screen will turn green. When there are 15 seconds left, the screen will turn yellow. And when time is up, the screen turns red and a bell will be rung. This means stop talking. Our questions will be asked in an alternating manner so that every candidate will have the opportunity to answer a question first. Whenever a question is asked, both candidates running against each other for a position will have the opportunity to respond prior to the candidates for the other position. I will be alternating not only between the candidates, but also between the positions for each question. Now that the rules are covered, we can get started. Candidates, are you ready? Great. The first question is, what qualifies you to be a judge beyond a law degree? And we will start with candidate Erb.
Thank you, Tanya. Thank you very much for the opportunity to be here and address the City Club membership today. I appreciate it very much. So in addition to my law degree, I have been practicing law for more than 15 years, representing the people on behalf of state, tribal, and local governments. I have substantial experience handling each type of case that comes before a Superior Court judge, whether that be a serious felony criminal case, a family law matter, or even civil law cases, which I've been handling on behalf of the City of Bellingham for the past 10 years. I also have substantial trial experience. I've tried approximately 50 jury trials during the course of my career. everything from misdemeanor cases, including driving under the influence offenses, up through serious capital felony cases punishable by life in prison. And so based on my experience, I have been independently rated as well qualified for a position on the court by 4 different state minority bar associations and qualified by 3 others, including the Whatcom County Bar Association. And I'm also proud to be endorsed by 3 Supreme Court Justices, Court of Appeals Judge Cecily Hazelrig, and even Whatcom County Superior Court Judge Deb Garrett, whose position I'm running for. Thank you.
Thank you very much, Candidate Erb. Candidate Jones, the same question?
All right, thank you, Tanya, and I'm happy to be here. So I appreciate the opportunity to speak to the City Club. It's organizations like this that are so important to democracy and educating voters. So it's great to be here, and I think on behalf of all the candidates, thank you. So I've been practicing in Superior Court for about 10 years. I know the court well from the inside, and then I think more importantly, and to the question of qualifications, I know it from the outside. I grew up in Whatcom County. I'm from here. My extended family lives here. And I have a connection, or I feel I have a connection with the people of this community, with the people of Whatcom County. And that's what the most important thing is as a Superior Court judge, is that we have someone on the bench that can see the people behind the cases and can really endeavor to listen to each and every issue that's before the court. And I feel strongly that that's a quality I have that's beyond a law degree, harder to quantify, and something I can bring to the bench. So I would offer that up as a qualification. Procedurally, I understand the court. I've been there. I try felony cases in Superior Court now as a criminal attorney. I have civil experience. I've spent 2 years in private practice in Bellingham, where I did land use law, some business disputes, and a variety of things, estate planning, and criminal defense work, where I represented individuals. So I feel I'm qualified and prepared for this opportunity.
Thank you, Candidate Jones.
Yeah.
We'll now move on to position 4, the same question. Candidate Freeman.
Thank you, Tanya, and thank you to City Club for hosting this event. I appreciate it. First of all, I've been licensed for about 15 years now. In that time, I've acted as a trial attorney, but the distinction here is that we're trained to be advocates, and the job of a judge is different. And it's about being fair and impartial, about being able to set aside our own personal feelings. And for that, I have almost 10 years of experience in a decision-making role. I spent 9 years as an administrative review judge. I spent most of that time, I was also acting as a pro tem or substitute judge in every municipal court in Whatcom County, as well as a substitute in Whatcom County Superior Court as a substitute commissioner. I've decided thousands of cases, both administrative, criminal, and civil. In addition to that experience, I have the track record to back it up. I've been evaluated by our local bar association, and I received the highest qualification, exceptionally well qualified for the position. I got the same qualification from 4 out of 5 minority bar associations, and a well qualified from the 5th. I was heavily vetted in my appointment process by the governor's office, and I would direct voters to my endorsements from the bench, the people that I've worked with, who I've been before, all of the Whatcom County Superior Court judges and district court judges, and my predecessor, Justice Raquel Montoya Lewis. Thank you.
Thank you, Candidate Freeman. Candidate Nelson, please.
Thank you, and thank you for having me. When I first got out of the military in 1974, I started working as a respiratory therapist, and I earned enough money so I could pay for my way through law school. And I entered law school, and my first job out of law school was with the Snohomish County Prosecutor's Office. I was a deputy prosecutor there. And then I went on to do 8 years of prosecutor work. My experience is 3 decades, not just as a public prosecutor, but as a public defender and a private practice attorney. So I've done multiple cases, landlord-tenant, I've done cases involving personal injury, and I did dependency representation. I've also been a public defender for 5 years. The hundreds of trials and hearings that I had in Superior Court, I learned from every single one of those as an attorney. And the important thing is that I represented people, human beings, and I've represented over 1,000 people, well over 1,000 people, and from every racial minority, LGBTO, drug-addicted people, homeless people.
Thank you, Candidate Nelson. We will start with position 4 first for this next question. Judicial interpretation refers to how a judge interprets laws, which may vary by state or county. How would you describe your method of judicial interpretation in Whatcom County? And we will start with Candidate Nelson.
I have worked as an appellate attorney in the Court of Appeals. I've worked as appellate attorney in the Washington State Supreme Court, as well as the United States Supreme Court. So I've had a lot of experience with interpreting laws and really getting down to the nitty-gritty of laws and the nitty-gritty of facts as they apply to the laws. I think that that type of experience is imperative, because that's the only thing that really prepares you, I believe, for a judicial appointment or position. I have had so many cases where I'd been up late at night, 3 o'clock in the morning, working on the case, and I've had many of those. And that's the way to be experienced and learn in the law, and somehow attain the judicial experience that is very relevant to a Superior Court judge position. I think without the appellate experience, one is very handicapped in trying to be a Superior Court judge.
Thank you. And Candidate Freeman, please.
Thank you, Tanya. First of all, I think it's important to define the role of a Superior Court judge. We're not an appellate level court, with the exception of appeals from courts of lower jurisdiction, district court, municipal court. And so we're bound by law and precedent. We're bound by statute. And for that, I have had the experience of nearly 10 years deciding cases based on the law. I also have had experience as an appellate attorney, both in the Court of Appeals and as a special deputy prosecuting attorney after I left the prosecutor's office, handling appeals from district court to Superior Court. So this is not something I'm unfamiliar with. I've also, as a Superior Court judge, heard appeals from district court. As far as the philosophy goes, the first thing is just simply following the law without bias. And I think that's the starting point. And how we construct statutory interpretation, we're also bound by law on that, and the appellate courts. And they've given us tools in order to interpret the law and how to apply it to facts. You start with the plain meaning of a statute, and then you apply various forms of statutory interpretation from there. My track record and my experience reflect a commitment to following the law, and that's what I intend to do in the future. Thank you.
Thank you very much. Candidate Jones, your response?
Thank you, Tanya. You know, the question, it's a great question. It's a very important question. It reminds me of when we conduct jury trials in Superior Court, we have potential jurors come to court. And one of the first things I always hope to talk to folks about and do is the different roles that the government branches play in our democracy, the separation of powers and what those roles are. So we go through the legislative branch, the executive branch, and the judicial branch. And it's so important to point out, and most folks expect and hope to hear, that the judicial branch is limited in what it does. And it really stands in the role of an interpreter of the laws, not a creator of the law like the legislator, and not an enforcer of the law like the executive branch, but as an interpreter of the law. And that I feel very strongly about that. And that's important to me, that that is the limited role that a judge should play within the judicial branch. And I would do that as judge. The philosophy that I think that endures is that a judge is not a king or a queen, and we can't expect, and we shouldn't hope for any sort of edicts from that person, but rather true, honest, and compassionate interpretations of what the law is as written. And that's looking at the text of the statutes. That's recognizing that you're controlled by higher courts and statutes as written, and that you're honest in that interpretation. And the ends don't justify the means, but we do a true interpretation of the law.
Thank you, Candidate Jones. Candidate Erb, please.
Yes, thank you for the question. And I think that the other candidates have spoken well to this issue. It is, the exclusive duty and province of the courts, including Superior Court judges, to say what the law is. And our philosophy about how we do that has to begin with the text of the law as passed by the legislature or the Constitution that we're interpreting. I think every first-year law student would tell you that when you're interpreting the law, you have to start with that text to see what it says. And if the plain meaning of the text is clear on its face, that's really the end of the inquiry as far as your interpretation. You're just applying that law and its plain meaning to the facts before you. I think that is the role of the judge, as the candidates have said, not to make the law from the bench, but rather to interpret it. And in those situations, when the intent of the language is not clear from the plain language of the text, you turn to the other tools of statutory interpretation that have been adopted by the courts, for several centuries in our common law system, to look to see what the meaning of that text is, if you have to look beyond the plain words, so that you can reach a result that is truly fair and just. And that is what I will do if I'm appointed or elected rather to this position.
Thank you, Candidate Erb. All right, we're going to start with position 2 again this time. Two-part question. The first part, what are your thoughts on managing a courtroom during our current coronavirus new normal with remote hearings and trials? Second part, does this impact equal access to a fair trial? And if so, how would you mitigate this to provide social equity? We will start with Candidate Jones, please.
Okay, thank you. What a relevant question. And I've spent some time, quite a bit of time over the last couple of months thinking about how our court and how Superior Court's responding to the pandemic and the effect that has on the community that relies on the court. I've made time to be involved where I can in the judicial conversations that are going on about COVID and the response that the court will have. I've sat in on bench trials and remote hearings that are being put together to try to respond to the pandemic. And I've tried to listen, and I've tried to learn about the best way to do it so that I can be informed if I'm have the opportunity to be on the Superior Court bench. What I found is a couple things. One, everybody's trying real hard. Everybody's making an honest effort to maintain access to justice because it's so important for everyone. It's important for inmates that are in custody. It's important for people that have family law matters and land use issues and things that just can't wait on a pandemic. So the first thing is that everybody's trying. It takes leadership by the judge. It takes leadership to say, this is how we're going to do this. We're going to set up remote hearings. We're going to invite the public in through technology into the courtroom, and we're going to maintain. The constitutional rights of everybody is so important. We're maintaining access.
Thank you, Candidate Jones. Candidate Erb, please.
Thank you. I think this is a really terrific question as well. The pandemic really affected the lives of everybody here in our community in Whatcom County and indeed across the country and the world. And we need to make sure that even though we are struggling with this issue, that our court systems remain open, remain functioning, and are able to provide justice to the members of our community who need it, whether that's a renter who's been wrongfully evicted from their apartment, or a victim of crime, or a husband or wife who's seeking a dissolution, or help in establishing a parenting plan for their child. We need to have a courtroom that is open and functioning. Like many professionals here in Whatcom County, I've gotten very used to the Zoom platform and GoToMeeting and the other electronic-based platforms for remote meetings and hearings. I appeared in front of Judge Freeman about a week ago on a remote hearing, and that process is ongoing, and it is important that we continue to do that. But there is no substitute for having courts that are open to the litigants and to the public to come into. And really, until we have leadership at the national and state level that solves this pandemic and gets us back to a new normal, it is going to create hardships for a lot of people. And I pledge to work as hard as I can to make sure that people continue to have access to justice during this time.
Thank you, Candidate Erb. We will start with you on this question. Candidate Nelson, please.
Well, it's extremely important as far as managing a courtroom in the COVID pandemic. It's extremely important that the courts remain open and available. And there really is no substitution for in-person hearings, in-person trials, and courtrooms that allow in spectators. So all those things have changed. And so far, the things seem to be going along smoothly as possible, but I think there's a backlog developing, and we need to really think in the future about that. As to the impact of equal access, of course, anyone who is having a jury trial in this virus environment, we have to deal with the whole idea of masks, and masks from witnesses, and masks by being worn by jurors. We need to be able to have a good voir dire where we talk to the jury panel to determine which juries will actually make it to the trial. And we also need to be careful about witness testimony, because the witnesses the jurors decide what level of credibility is going to be given to a witness. And they do that by observing the witness testify, hearing their testify, and observing their demeanor.
Thank you, Candidate Nelson. And Candidate Freeman, can you share your thoughts on that?
Yes, thank you. Well, just as a timeline, I was appointed in the end of January, took the bench early February, and by March we were in a pandemic. And you can plan for a lot of things when you take the bench in Superior Court. This was not one of them. I think I agree with much of what was said by Candidate Nelson and the other two candidates as well. First, keeping the courtroom open. And we had to massively shift the way we did business early on. We were not set up to do remote hearings. We were not set up to do telephonic or video hearings exclusively. We also didn't have the safety procedures in place. So what we did was we took the 3 judicial officers that were of the least likely to be impacted by COVID, and we took on all of the in-person hearings. So myself and 2 other judges. We quickly adapted to allow for video conferencing and appearances remotely. I found myself at times, sending my judicial assistant out at lunch to get some sort of cord to connect something else, or up on my bench, changing cameras in the middle of a hearing. It takes significant adaptation, and we've been continuing to do that. I'm on a task force to get our jury trials back going, and I'm heading up that effort because it does have significant impacts. And we've tried to do things in order to address the equities, including waiver of signature and things of that nature. Thank you.
Thank you, Candidate Freeman. We will be starting again with position 4 this time. And we have the next question, which was, how would you define a conflict of interest in your courtroom? Candidate Freeman, we'll start with you.
Yes, thank you. Well, we're guided by the ethical rules to begin with. And anytime that I perceive a conflict with a case, whether I know a witness, there may be, or I've somehow know the case and some other factor other than as an unbiased decision maker, I always either recuse or if it is a conflict that I don't perceive being an interest, I will then let the parties know, because transparency is key. What voters expect and what we all expect of a judge is to be fair, impartial, unbiased, open-minded, and it's essential for transparency with that regard. So if there is a conflict of interest, I take that very seriously, both in my recusal and my transparency to the parties so that they can make their own determination. This is an ongoing issue that I deal with on a weekly basis. Thank you.
Thank you, Candidate Freeman. Candidate Nelson, your thoughts on that?
Well, from a perspective of judicial independence and judicial autonomy, I think we need to make some changes in the way that we select judges, because I have had people come in and say to me, people sitting next to me as their attorney, and say to me, how can I possibly get a fair trial in this courtroom when the judge was endorsed by the sheriff, and the judge was endorsed by the prosecutor, and the judge was endorsed by mayors and that? And it's a good question, because I hear that a lot. I hear from my clients that they're all in this together, the judge, the prosecutor, and the police. And it's not just the clients I've spoken to. I've spoken with judges throughout my career, and they talk about being terrified that the prosecutor will pull their endorsement, or worse, endorse the other candidate in the upcoming election because of decisions that they've made. And I'm not knocking police and prosecutors. I have a tremendous amount of respect for them. I think we just need to have a clear, bright line between the judge and the parties. That means that the judge doesn't take endorsements from anyone. And the judge doesn't take campaign contributions. So I'm not taking contributions. I'm paying for my own campaign. I'm not taking endorsements because I think it creates liabilities for the judge, and it creates obligations.
Thank you, Candidate Nelson. All right, with position 2, we will start with Candidate Erb, please.
Thank you. I think this is an important question for our community to ask itself. I think, judicial officers are supposed to be independent, impartial, and act with integrity at all times. And the community will have to decide whether electing a person who works in the deputy prosecutor's office and who has been doing that for the past 9 years will bring the type of independence to the bench that the community will feel comfortable with. I think that is a real question in this race to determine whether or not the community is comfortable with that. I think that we want to make sure that we don't only just have that independence, but also have the appearance of fairness for individuals who come into the courtroom to make sure that they can feel like they are being heard and that their case is getting judged based on the facts and not on any personal relationships or as Mr. Nelson or Candidate Nelson, I beg your pardon, was referring to, any endorsements or any sort of obligations that are being brought to bear in that regard. So I think that it is something that's important to bring to the bench, is that type of independence, and that is something that I offer to the community. In this case, I have been referred to as the outsider rather than the insider, and I think that that's true. But I think for the role of a judge acting as a neutral, it is important to have that type of independence and bring that to the bench.
Candidate Jones, would you like your 30-second rebuttal?
Yes, please. Sure. I was mentioned specifically, I guess by Candidate Erb about my work history, and it strikes me as in response that what I'm hearing there is kind of somebody and some willing to judge me entirely on a job that I've had, and I don't think that's an appropriate thing to do. So we work off our what we say in the community, what we believe, and what we talk about, and not what we've done for work. Because I've done a lot of things for work, and to pick out one thing and to kind of judge me entirely based on that, I think is inappropriate.
Thank you. And now you have an opportunity to answer the question, which was, how do you define a conflict of interest in your courtroom?
It's a great and important question. And I want to be real about it for a second, because we all the legal community in Whatcom County, out of which come the judicial candidates, is a small community. We know each other, we work together, and the ability to have people that we've worked with who understand our experience, who understand our abilities, our intelligence, our compassion, that understand those things, for those people that have worked with us to have the ability to talk to voters and to say, hey, this is somebody that we can trust. This is somebody who's done good work, and I've seen it. We've seen it. The ability to say that through an endorsement is essential. It's important. It's important that the voters get that information, and that we don't run an election blind and for the voters. And that's why I see the endorsements, and especially the endorsements of folks that have been involved in what the Superior Court judge is going to be asked to do are important. So I see that as a good thing and not a bad thing. What's important is that we maintain independence once we're elected as judge, and always. And that's something that the candidates can tell the voters directly, is that's what will happen in the courtroom. There's no marching orders besides following the law for every person and looking at every person in the eye and endeavoring to do justice. And that has nothing to do with what jobs we've had. It has a lot to do with who we are.
Thank you, Candidate Jones. And our next question will be for position 2 again. What resources have you utilized to educate yourself on systemic racism in our justice system? And how has it influenced your approach to the law? And we'll start with Candidate Erb, please. Oh, you're quiet.
That was bound to happen to me at one point. So that's a terrific question. And there is no shortage of resources, thankfully, around these important topics. We have people out in the streets in different communities across our country right now railing against systemic racism and the injustice that they see in our criminal justice system particularly. And so I've worked to educate myself by reading some of the research that has been done around this topic, some of the scholarly articles, as well as some of the books that have been published. I listen to podcasts and radio programs regularly that are put out by Black leaders and other people of color around these issues. I read as many news articles as I can to understand better the suffering by people of color in the system, and to try to think really carefully about the proactive steps that we can take as a justice system to ease some of that suffering and to really make it more fair and just for everyone, regardless of your background or your personal characteristics. And I think this gets back again to the idea of independence and making sure that we have judges who will hold prosecutors accountable when they're not following the rules or when they're being unfair, and as well as law enforcement. And so again, I mean, it comes back to that independence that we were just talking about a moment ago, and that is something that I bring to this race.
Thank you, Candidate Erb. Candidate Jones, the same question.
Okay, thank you. Boy, what important and pressing question for all of us. It's good that we're being asked about this, and just the fact that we are is such a demonstration of why it's important and why it needs to be addressed in our courtrooms and in all of our selves. So I've been working hard over the last months to educate myself, to listen. I appreciate that the role of a judge, if I'm lucky enough to have it, is one of not a policy maker, but one of a true and genuine listener to the community and to the people that are affected. And so that's really what I've been trying to do on this issue. I understand that I'm not the solution. I'm not going to be, none of us here are going to be the solution, but we need to be prepared and willing to be a part of the solution as it happens. And that's what I've been doing is listening. I've been talking to folks. I've been taking their advice on what I should do and how I should prepare myself to be an ally. I was referenced to a gentleman who lives out on Orcas Island. He was an ex-police chief in the city of Seattle during the WTO riots, and has some amazing perspective on how folks in the system should respond to the demands of the people, which are appropriate. And so I'm listening.
Thank you. Candidate Freeman, please, your response.
Thank you. And as Mr. Jones indicated, this is a very timely and appropriate question right now. So as a starting point, I think any candidate needs to recognize that systemic racism still exists, including in our own system, including in our own judicial system. And that's a starting point that I think we're fortunate to be in a state where our Supreme Court has taken leadership on this. They've outlined an approach as far as recognizing that systemic racism exists, as far as listening to the communities impacted, challenging our own philosophies and our own approaches, and trying to lift up the voices of those impacted. And I think that's a very wise piece of advice coming down from the Supreme Court. And I have tried to follow it since they've put down their letter. I was part of a book club where I introduced myself as a candidate maybe 2 months ago. And I actually learned more from them than I think I may have conveyed to them. And they directed me to a number of books that I've now downloaded and I've been listening to when I have time on racism, on systemic racism. I found that helpful. I've also attended the listening sessions with the county leadership. So I've observed those listening sessions. And this is an ongoing process. I think a lot of it is listening right now and then taking action and determining how we're going to take action. And I don't pretend to have all the answers.
Thank you, Candidate Freeman. And Candidate Nelson.
Well, I was listening to the news a while ago, and a sheriff in one of the areas where a lot of riots are going on said that people need to trust in the criminal justice system, but they don't. They don't. Now, I have a unique perspective, and I've utilized all the resources previously talked about, but I have a unique perspective that I am talking with people that are of minority races all the time at the jail where they're locked up, or alongside of me at council table. And this is a subject that we talk about a lot. Can I be treated fairly here? And candidate Erb referred to judicial independence again, because as I said previously, they're always looking up at the judge and they're always looking at the prosecutor and saying they're all in this against me because there was endorsements. We need non-endorsements, no endorsements for judges in the future. So having all this contact is really important. Contact with the people that are talking about what it's like to be a member of minority race in the criminal justice system. I represented a Hispanic male back in 2001, and I took the case to the state Supreme Court, and it was an issue on, was the jury a fair racial representation of the community? I argued that it wasn't. Unfortunately, Supreme Court disagreed with me in a 5-4 decision, so it was very close.
Thank you, Candidate Nelson. You might get to continue your thoughts because you get to answer the next question first.
Okay.
The next question is, the news in our streets have been filled with outrage over cries of police brutality and for social justice. Do you have ideas on how our justice systems can be improved, and how will you work to make those changes happen?
Well, let me start out by saying that I've worked in this field for 31 years, and I've worked as a prosecutor for 8 years, and I've known an awful lot of law enforcement officers. And I can tell you that the things that we're seeing on these videos, these ugly videos where people are being obviously abused by the power of the state through the certain police officer, those are in the minority. There's not very many of them. But it's amazing to me that any of these things are happening at all. Before video cameras, what was going on, and we don't know because there's no cameras, but my clients will tell me before that, there was a lot of this stuff going on. So I don't think it's right to blame police agencies, prosecutors, police chiefs, or anything like that. There are some people that just should not be police officers, and they need to get better and better at weeding those people out. And they need to get better and better at making sure that they don't work in law enforcement. So, that being said, we still have this problem now, and it's got to come to an end because this is just going on for too long. My dad told me in the 50s about riots that were occurring in Chicago when he was a child in like 1914 or something like that. And now I've seen a lot of riots in my lifetime, and it just happens and happens and happens. So we got to make a change. And one of those is improving judicial autonomy.
Thank you. So candidate Freeman, can you share your ideas on that one? Uh-oh, you're muted.
I'm sorry.
No worries.
Yes, I can. And first of all, I just want to define the role of the judge. And while I completely understand the community's position, and we, at the end of the day, have to be fair and impartial to everyone that comes before us. And so I think I have to make that the starting point. And I'm also going to address the endorsement issue that was brought up. And, I have endorsements from law enforcement, and I have endorsements from people on the social justice front, people like Dr. Johnson and a number of councilmen that have been at the front of this. So I would say my endorsements are very, very balanced when it comes to that, and it reflects the fact that I can be fair and impartial to everyone that comes before me. So how do we solve the problem that we can solve within the court? I think there are a few things. We can look at how we select juries to make sure that we are getting an accurate representation, something that Mr. Nelson brought up. That can go towards how we look at preemptive challenges, meaning striking jurors for no reason at all. That's one thing we can look at. We can do better at educating communities, especially impacted communities, about our role in the court, about the importance of jury service. I think that's the role of the judge, is education and letting people know how important it is and that it can be a safe place, and that everyone will be respected in the courtroom. Thank you.
Thank you. I'm debating here. Candidate Nelson, Candidate Freeman kind of mentioned you a little bit. Would you like a 30-second chance to respond on endorsements?
Sure, I think it's important. I think it's important that the judges themselves that I spoke to throughout my career have been affected by the endorsements. And they've actually told me about this. They said, I'm worried I'm going to lose the endorsement and I won't get reelected. I'm worried the prosecutor, the police agencies are going to endorse my opponent in a future election. That's the problem. And that's why we need to remove this issue. We need to remove this issue from the way we elect judges.
Okay, thank you. And now we'll continue with the question with position 2. Would you like to rehear the question, Candidate Jones? Because we're going to start with you.
I think I remember the question, so I
Okay,
can
great.
go ahead, but because it's important. So it brought up to me immediately a story that I have from my own history, which is when I was in private practice. I was a civil lawyer, and one of the cases I took was a lady from Skagit County who came in, who had an interaction with a police agency there that was unacceptable. It violated her rights, and it conveyed a message to her from the police of that she was less important. She was a middle-aged African-American woman from Mount Vernon, and together, I listened to that with every word, and together we filed a civil rights lawsuit. And we did something about it. So, as far as what can be done to end what's happening to minorities, what's always happened to minorities in this country, what can be done to end it is people standing up and doing something about it. And it's not, I agree with Judge Freeman, it's not necessarily judges, but it's people that enter those courtrooms and say, look and listen to what's happening. And I had that experience in private practice as a civil lawyer with a client, a real client who had experienced it. So I know that, and we all need to stand up. And we all need to say what's happening, and we need to do something that we can about it.
Thank you, Candidate Jones. Candidate Erb, can you share your thoughts on this?
Sure, it's an important question. And I think if people are not outraged about what is happening with what we are seeing regularly with far too much frequency on the news about typically unarmed Black men being killed by law enforcement officers and there being no accountability, then you're just not paying attention. Because it is outrageous, and we should be outraged by that. And I think there are multiple issues that we need to talk about in order to make that system better. We need to have true accountability for law enforcement when they do commit serious misconduct. We need to have systems in place that hold officers accountable when they exercise poor judgment, because what they do is they're demonstrating that they don't have the judgment necessary to safely enforce the laws in our community. And in my career at the city of Bellingham, I have worked closely with the Bellingham Police Chief and the Human Resources Department to hold officers accountable when they do commit misconduct, so that those officers are not in a position to go out into the community and commit further misconduct. And I'm proud of that. I also think that we need to establish trust between the law enforcement community and the communities that they serve. And that's a really difficult, tall order right now. But I'm proud to see people like Chief Dahl and Mayor Fleetwood working on that. And I think that, there are so many other things that I could talk about, including the peremptory challenges that Judge Freeman mentioned, which I think we should eliminate to create more of a system that's fair and balanced.
Thank you, Candidate Erb. All right, we're going to be starting with position 2 again. And the next question is, are there ways to make domestic abuse cases less traumatic for victims? How would you attempt to do this? And we will start with Candidate Jones on this one.
Okay, thank you. I have a lot of professional experience with handling domestic violence cases that find themselves before the court. And I'll tell you, I both professionally, but also in my private life, I'm a board member of domestic violence and sexual assault services. So I've been involved in these issues and the issues of domestic violence and family violence, and been involved in trying to address them. And Tanya, your question about the effects it has on the people that are the victims, the survivors of this violence is incredibly important. I've seen that every day as I've sat across the table from people that have experienced violence in their homes, and I see the effect it has on them, and I see what the system is asking them to then do, to stand up and be strong and be tough and go to court and confront their abuser, drag their kids along for the ride. All these things need to be. It's incredibly important that a judge has the perspective to appreciate that. And that's part of looking at the people behind the cases. It's not just, here comes another DV case. It's a person that's been affected, and appreciating that as a starting point. We work on tactics to do what we call evidence-based cases, where it relies less on survivor testimony, but we all need to listen.
Thank you. Candidate Erb, please.
Yeah, I'm proud during the course of my career to have helped many survivors of domestic violence receive some measure of justice through the criminal justice system. I have worked with children who suffered sexual abuse from relatives. I have worked with spouses who suffered physical and emotional and psychological abuse from their partners. And I have worked with them through the system to help them to understand it and to connect them with the resources that can help them deal with that ongoing trauma, because it is exceptionally traumatic for survivors of abuse to suffer. And they do need access to the resources that can help them to deal with that trauma and to get well. And then we do have many professionals here in the Whatcom County community that do provide those services to victims. Candidate Jones mentioned being on the board of DVSAS, and then the professionals at DVSAS that have the ability to meet and speak with, they're great at what they do, and we need to support those types of professionals. Similarly, the professionals at Bridget Collins, who help children who've been abused. I mean, they're outstanding at what they do, and we need to provide them support, and kind of linking the victims up with those types of support services in our community, and making sure that when victims do come into the courtroom, they understand that that place will be a safe and welcoming place for them, where they will be heard by the judge who's sitting on the bench.
Question number 7, are there ways to make domestic abuse cases less traumatic for victims? How would you attempt to do this? Candidate Nelson, we'll start with you on that.
Thank you. I think all the candidates will agree that all of these domestic violence cases are different. I have read probable cause statements, police reports, spoken with victims of domestic violence, and some of the facts are so incredibly harsh and ugly that it makes you feel very angry and very empathetic toward the victim. On the other hand, we need to recognize that there are some cases where, I'll give you an example of, I had a case that I was prosecuting some years ago, and I was speaking with the victim, and I asked her to tell me in her own words what happened, and she kind of smiled and said, well, you know, I knew that arrest is mandatory in these types of situations. And if I said that my boyfriend had assaulted me, that he would be arrested on a Friday night, and I would have the whole weekend to myself, and he might get released, probably get released on the following Monday. But what I wanted was to be alone for the weekend and just relax, and I didn't want him around, and so I called the police. And that's a true story. And obviously, as a prosecutor, I immediately dismissed the case. And I'm not saying that happens all the time, but it does happen. And I've seen several cases that do. But I have had a lot of experience working with battered women's shelter, as well as the Bridget Collins, because I've worked with children in this area that have been abused.
Thank you. And Candidate Freeman, your response, please.
Thank you. First of all, I'll talk a little bit about my experience. I did handle a number of cases as a prosecutor involving domestic violence. I was also on the leadership team for the Whatcom County Coordinated Domestic Violence Response Protocol that was put into place back in, 06, maybe, 07. I was also on the board of directors of Lydia Place, which domestic violence impacted a number of our clients. So that is the background I have. And something that Mr. Nelson said that I completely agree with is the need for impartiality as a judge. So we're lucky enough to have in Whatcom County a number of resources like Bridget Collins, like DVSAS, like some of the homeless programs that deal directly with issues involving domestic violence, like Lydia Place. So we are lucky enough as a community to have those resources, and resources available also to the court to some extent. But as a court, ultimately, we have to be fair, we have to be impartial to any case that comes before us. How do we reduce the impact as far as it has on the survivor? Well, a couple of things there. One, you start by treating everyone with dignity and respect when they come into the courtroom. And that includes, and I think potentially true or significantly true of people that have undergone trauma, like survivors. The other thing is, with COVID, we've moved to a different approach to things, and I'm hoping one of the silver linings there is maybe we have the opportunity, at least with victim impact statements, those could be done remotely and potentially lessen that trauma on survivors.
Thank you, Candidate Freeman. All right. The next question will start with position 4 again. And that question is, what does injustice look like in the courtroom, and how would you address it? Candidate Freeman, we'll start with you.
Well, I think, again, as a judge, we have to be careful here, or as a judicial candidate, we have to be careful here about what is and what is not injustice, and what our role is in the system. I think we're the referees. We have to make sure that people are playing by the rules and that everyone is treated the same in our courts. And so how do we do that? Well, we apply the rules equally to everyone that comes before us. We remain impartial. We set aside any biases that we may have. And that's the key to providing an impartial court in order to avoid those types of injustices. We can't be afraid to hold people accountable when necessary and when the law requires it. Clearly, we've seen some of that in communities throughout the country. And I think as judges, we can't be swayed by politics or anything else but the facts in front of us, and make our decisions based on those facts and the law at hand. And I think that's how we deal with injustice. The judicial system plays a critical role as being the counter to the other two branches of government. And we have to remain independent in order to provide that check. So the other thing that we can do is the barriers of justice. One of our jobs as judges is to educate the community and to try to lessen the barriers that people have in order to be before the court. So that is my position. Thank you.
Thank you. Candidate Nelson, please.
Well, the question was, what does injustice look like in the courtroom? And as somebody who has represented a lot of people as their defender or in some other type of a dispute, I can tell this panel, and I think that candidates will agree with me. Well, I don't know whether they will or not, but I tell you specifically, when I have a Black client that testifies at a hearing, not just at the jury trial, the hearing where the judge needs to decide whether or not this person's telling the truth. When I have a Black client that testifies and what he testifies to is conflicted, receives conflicted testimony by a police officer, 100% of the time the judge finds that the police officer is more credible. And that's been over the years, and that's been a constant thing. And I've seen that a lot. And it's not just with Black clients. I've represented a lot of people from the Black race, as well as Hispanics and other types of minorities. And I see this a lot. When you have one person that says one thing and another person that says another thing diametrically opposed, who gets believed? It's always going to be the state employee, the police officer, or some other state employee, always. I've never seen it happen any different than that. So that's what injustice looks like. And I'm just getting started on this. And I said I don't have any time left. But I think that that's a big injustice that I've seen throughout my career.
Thank you. So we'll go on to position 2, and we'll start with candidate Erb, please.
Yeah, thank you for this question. So I think it's important to note that a lot of the injustice that people feel in our justice system, a lot of that has its roots outside of the courthouse. Specifically about things that take place inside the courthouse, I agree a lot with what Judge Freeman had to say, which is, as judges, as that check on the power of the executive, oftentimes exercised by law enforcement, as the check on the power of the legislature to pass laws which would lead to unjust outcomes. That's where the role of the judge really comes in, is to making sure that it's serving as that check on the other branches. And also, importantly, treating everybody who comes into the courtroom with the dignity and respect that he or she deserves, regardless of their individual characteristics. We want to make sure that our courtrooms are safe, welcoming spaces for everybody, so that when they come into the courtroom, they feel comfortable and confident that they will be able to present their case to the judge and be heard on the merits of their case. And that does not mean that you're promising outcomes, because as judges, we can't do that. We have to be completely independent. We have to be completely impartial. But the goal of a judge, or at least one of their goals, should be to make sure that everybody who leaves the courtroom leaves knowing that their case was heard and they got a fair shake, regardless of the outcome.
Thank you, candidate Erb. Candidate Jones.
Thank you, Tanya. I think injustice inside the courtroom looks a couple ways, and one and kind of the one we see, those of us that are in the courtroom, is when people aren't heard. And because for whatever reason, their ability to be in the court and to present to the court is affected in such a way that they're not heard, or in the alternative, you have a judge that isn't listening. And there is true and everyday injustice that happens because of those things. the judge has a role there. The judge, most importantly, has a role to never be in the position, never put others in the position that injustice happens because the judge isn't listening. That can never be the case. The other place I see injustice that happens in the courtroom is kind of a bit more abstract, but just as real, which is that people never show up in the first place. Their access to justice is denied from the get-go because of systemic barriers, because of education, because of intimidation, all these things that keep people from the courtroom to start with. And there's injustice, significant injustice there. So the judge has a role there as well. And, you know, I teach law at Whatcom Community College, and I have for years. And the role of a judge as an educator to the community is an important one that I take seriously, and something I would add to the bench and hopefully make some steps, some positive steps on this question.
Thank you, Candidate Jones. So the next question is, what are your thoughts on zero tolerance policies? And we will start with candidate Erb, please.
I'm curious. I don't know, Tanya, if you can elucidate a little bit more what you mean by zero tolerance policies, what we're referring to.
Well, I would venture that would kind of be in alignment with 3 strikes and you're out, that type of thinking.
Okay. Thank you. It's helpful to have a little bit more understanding about what the question is trying to get at. So thank you for this question. You know, in my experience as a prosecutor, one of the most frustrating things that I had to deal with was 3 strikes laws, mandatory minimum sentencing, situations where the legislature took discretion away from the judge or judicial officer to make a decision based on the facts, on the individual before them, and resulted in a decision that in some cases was unjust. There were cases that I handled where a defendant no doubt had committed the offense that they were accused of. However, the mandatory minimum sentence for that offense was not fair or proportional. And yet that was the law that was handed down. And as a judicial officer, you know, you don't have the ability to disregard that. So when the legislature adopts those laws, as a judge, your discretion is removed and you have to sentence accordingly. And as a judge, you know, that is the job that you have to do. And so, I mean, it is really hard to overstate the impacts that mandatory minimum sentences can have on people or 3 strikes type laws. Because it does really remove the discretion from the judge, and it takes that discretion and it shifts it to the prosecutor's office, where they're going to decide what are the charges that are going to be brought to bear here. Are those charges going to carry those types of sentences or not?
Thank you, Candidate Erb. Candidate Jones, please.
This is an important question, and what it brings up to me almost immediately is when you're in a world of zero tolerance. What that means is that you're not taking into consideration all the facts and circumstances that have put the people in the courtroom in the first place. And if this is in a criminal context, you, because of your directive to have zero tolerance in whatever the circumstance is, you are ignoring circumstances of individuals. And we can never do that in the courtroom. I've learned over the years, trying cases and meeting with survivors and meeting with defense attorneys and being a defense attorney myself, I've learned that the circumstances are what is most important here. What happened and the circumstances that arrived us there. And those can't be ignored. And I know sometimes it's cleaner and easier to just say, well, you did it, and now this is what happens to you. And that's what zero tolerance policies engender. And it's an ostrich thing. It's a head in the sand thing from those in the courtroom that make it easier for them, but shouldn't be allowed. We need to understand what brought people to the courtroom when they're there, and because that's how we achieve justice, and that's the most important thing.
Thank you. Candidate Freeman, can you give us some thoughts on that?
Yes, thank you. First of all, I do want to be cautious here because as judicial candidates or judges, we have to be careful not to take political stances, make pledges. That's in the canons of judicial ethics. So I think what I can say is I certainly understand the issues with zero tolerance policies. I've seen them as a prosecutor. I've seen them in my life before being a judge. And I completely understand the frustration. I can talk about what frustrates me as a judge, which is that it essentially binds our hands, and something that both candidate Jones and candidate Erb brought up is it takes the discretion out of the hands of the court and almost bifurcates the system, because you're left does this amount to what the legislature has created? And if it does, then we're bound to follow it. And that's our role as a judge, is to follow the law as it is, not necessarily how we want it to be. And I think that is one of the most difficult things as a judge, is setting aside the passion we may have personally. We're all humans, and we may feel very passionate about certain things. The problem is we can't apply that to our reasoning in the courtroom. We are bound by the law as it is, not how we want it to be. And so I can say it is frustrating when the system or the judicial system is taken out of the equation to an extent. Thank you.
Thank you. And candidate Nelson, can you share your thoughts?
Well, I'm not one to say, and I won't say, that judges can't do anything about injustice that they see in their courtroom. I think if a judge sees injustice, he needs to do something about it. And I think he can do it without violating the laws or the judicial canons. Judges have a lot of power inside and outside the courtroom. Judges go to judicial liaison meetings all the time with the prosecutors and the defense attorneys. And they talk about things and they work things out. They have an influence. They're able to do those things. So I'm not saying that I'm not going to agree with this, that their discretion is removed and their hands are bound. And they don't just have to go along with an injustice that they see. Sometimes you see an injustice as a result of this whole plea bargaining progress, where someone is overcharged just in an attempt to a plea bargain down to a lesser charge, which he or she may not even be guilty of, but you threaten him with a higher charge. I mean, and sometimes people are a victim of an overzealous prosecutor, a prosecutor wanting to make his or her name on a case because it's a high profile case, it's in the news. I saw Attorney General William Barr actually said yesterday, talking about this type of thing. He said there are prosecutors who seek to boost their own profiles in a high profile prosecutions. And I'd like to say that we don't see this headhunting in the Department of Justice, that would not be truthful. I see it every day. So judges should be on guard against that type of thing as well, and use their unlimited power to do something about it.
Thank you, candidate Nelson. So I have one more question before the closing statements. I'm debating between two, of course. I think I'll stick with, how will you balance being an independent judge and an elected official? I know, let's see, we will start with candidate Nelson because he likes that question. Right?
Well, is this? Not that I like the question. I don't like the issue at all. I think it shouldn't exist. And we've got a situation where judges are being politicized. The whole judicial appointment system, the whole judicial election system, this whole endorsements business. You know, endorsements are meaningless for another reason. I've seen people that have endorsed my opponent that I don't even know. I've never met Mr. Ritchie, the prosecutor. I've never met the sheriff of Whatcom County. I am an outsider. As Mr. Erb said, he is the one too, but I'm an outsider. I've worked in 5 different counties for over 31 years, so I've never been a constant fixture in Whatcom County. I've worked in Whatcom County. I've worked in their municipal courts and their district courts and their superior courts. But no, I don't like politics at all involved in the selection of judges. I think it's inappropriate. I think it puts pressure on the judge. I think it puts pressure on the attorneys who bring their cases in front of a judge, knowing that the judge was endorsed by the his opponents in the courtroom's own client. or the prosecutor or whoever it is that endorsed the judge will affect their case. And people see that and they don't like it. And I'm telling you something, it's something that my clients have talked about a lot, that everybody is all in this against me, the judge, the prosecutor, and the law enforcement. And we need to stop that. We need to improve our system of justice so that people will have faith in the
Thank you, candidate Nelson. Okay, and candidate Freeman, your thoughts on that one?
Yeah, first of all, look, this is the system that we have. I didn't create the system. This is a system that the voters have had multiple opportunities over the years to change, and the voters have decided that this is how they want judges elected and appointed. And that's where we're at with that. I'll talk about the fact that I think it's disingenuous to say that the appointment process is purely political. I was heavily vetted by the governor's office, by an independent counsel in the governor's office, and chosen over a number of other qualified candidates. It was done by being vetted by our local bar association, where I received an exceptionally well qualified rating for the position, as well as 4 of the minority bar associations giving me the same. So this is about principles and not politics. This is about a record of mine of 10 years of service to our community and on the bench, of being fair, impartial, and treating everyone who comes into my courtroom with respect. And that's a documented track record, and I'm happy to stand by it. I also don't hide from my endorsements, nor do I owe them anything. They are simply a reflection of the track record that I have in serving our community. I am very proud to have endorsements from both prosecutors, defense attorneys. Both political parties have now endorsed me. This is not about politics. This is recognizing my experience over the last about 10 years as an independent decision maker. Thank you.
Candidate Jones, can you please share your thoughts on that one?
Sure, thank you, Tanya. I see the elected, the system that elects judges as somewhat important. And it's a little different perspective, I guess, but being accountable to the people through the electorate, through the election process is an important and historical thing in our democracy. And I see that as an accountability to the people that reminds the judge every day of his or her obligations to justice, because that's why they're put there by the people themselves. And so the process of having those voices heard, the voices of the people heard, is I think is a good thing, and it's an honest thing in the system. So I would say that the issue on the endorsements, I think a distinction needs to be made here. If what we're having is blindly political endorsements, I endorse him or her only because they are part of my political party, that's a problem. If what we have instead is endorsements that are more like job references, when you apply for a job, your prospective employer calls your old employer and say, how is he? How is she? And if your endorsements look more like that they come from all segments of society and all people and people that know you personally, then it's information the voters deserve and need about who you are, because otherwise they don't know you. Reaching out to people over Zoom calls only gets us so far. And so you need to look at the endorsements and make a determination.
Thank you, Candidate Jones.
Yeah.
And Candidate Erb, can you please tell us about your thoughts on being an independent judge and an elected official?
Absolutely. I think, as I said earlier during the program, judges need to be independent. They need to be impartial. They need to act with integrity. And the public has to have confidence that their judges are doing that. I heard a lot of discussion about endorsements from the other candidates, and my endorsements, I'm proud of every endorsement that I've received, and I am transparent about it. Every person who has endorsed me, their name shows up on my website. Every organization who has endorsed me, their name is on my website as well. So I'm proud of those endorsements. And I think that being endorsed by 3 Supreme Court justices does speak to my experience and my qualifications for this position. And I think that being endorsed by Judge Deb Garrett, whose position Mr. Jones and I are running for, speaks to my experience and my qualifications for the position. So I think that that's important. But one thing that I have not done is hidden any of the support or the endorsements that I have received. I have not, tried to portray myself as being independent while also using a political party here in Whatcom County to send out fundraising emails on my behalf, which I do not think is transparent. And I think if we are going to have a process that is an election process, we want our candidates to be truthful and honest about where our support is coming from. And I have been.
So if I'm hearing you correctly, you're implying that your opponent has done some of these things. So if you'd like 30 seconds to respond to that, candidate Jones, you may have it.
I appreciate that, Tanya, because I think that implication wasn't entirely subtle. So I'll say this: both candidates, myself and Mr. Erb, sought the endorsements of all the political parties, and really talked to everybody that we could. I think that's what I did, and it wasn't one-sided. It wasn't hidden or suspect in any way. But it was an effort in my mind to reach out to all the people in Whatcom County. And I think candidate Erb did the same thing, because I know he sat there and sought the endorsement of the Republican
That's
Party.
your 30 seconds, sorry.
Yeah.
Okay, so we are going to go on to closing statements. And for the closing statements, we get to start with, in the reverse alphabetical order of our beginning, with candidate Nelson.
Okay. So I want to clarify a few things, because we've talked a lot about a lot of things, and it's been a good discussion. And I thank all the candidates for participating. Clarify, number one, I'm talking about being endorsed by elected officials. That's the problem. The prosecutor, the sheriff. I'm not talking about political parties. And one thing I need to mention is that Mr. Erb and Mr. Jones and I were not vetted by the government because we didn't apply for the position. I mean, if one of us would have applied for the position, then we would have gone through the vetting. And we didn't go in front of an association of attorneys or the Minority Bar Association and be evaluated, because only the people that applied for the position will do that. So the problem is that I mentioned before, that people, even elected officials, endorse someone and they don't know the other candidate at all. And they don't know anything about either candidate. They've never sat with them in a trial and really closely viewed their work, and they've never did that with the other candidate as well. So they don't know them. And so it's not a genuine It is not a genuine endorsement. It's not genuine at all, because they don't have the experience with both of the candidates. Now, I would agree that if you're doing a cost-benefit analysis of some sort, which is the best, that would be good. But this is not what's happening here.
Thank you. Your closing statement, candidate Freeman?
Yes, thank you. First of all, in applying for this position, I didn't take that lightly, and it wasn't something I did overnight. It was something that I reached out to people I trust and know, and I was encouraged to do so. This is essentially my second phase of being vetted, first by the governor's office, by my local bar association, and by minority bar associations, and now by the voters. And I'm running on my record. I'm running on the nearly decade-long service I've provided as independent, fair, impartial fact finder and decision maker, who treats everyone with respect who comes into this courtroom. I'm running on that record. And what my endorsements and what my ratings reflect is that record. That is how I received the ratings of exceptionally well qualified by our local bar and by the minority bar associations. That is why I have the endorsements of all of our Superior Court judges and our district court judges and every municipal court judge who I substituted for. These are the people that know me, that have seen my work over 15 years. I'm not asking voters just to trust me. Just trust me because I have X amount of years experience. I'm giving objective proof as to my service, and that's what those endorsements reflect. I'm also proud of the broad base of support I have throughout Whatcom County, as I said, from all walks of life and political political parties, both Republican and Democrat. Thank you.
Thank you. Candidate Jones for position 2, your closing statement, please.
Thank you, Tanya. You know, I'm really seeking to be a candidate for all the people of Whatcom County. And that's important to me. It's important to me because of growing up here and just being a part of this community for as long as I can remember. So I'm really hoping to speak to each of you directly and tell you that I will be a judge for all the people. There will be no agendas in my courtroom other than following the law and respecting the rights of each person that's there. And that's incredibly important to me, and I make that pledge. I'll tell you, in my time practicing law in this community, I've been dedicated to public service, and it demonstrates really what's important to me. And I've shown that dedication. I've practiced in just about every courtroom in this community. I've been in Bellingham Municipal Court. I've been in Whatcom County District Court, Whatcom County Superior Court, Linden, Ferndale, Blaine, Sumas, Everson. I've been in all those courtrooms, and I've seen the cases that are there, and I've seen the people that are there. And I really can't emphasize enough that's where I think I can add to the bench is being someone that understands the people that are there and shows compassion for why they're there and the circumstances that are why they're there. I've been a prosecutor, yes. I've tried serious cases as a prosecutor. I've also been a defense attorney. I've also been a civil lawyer, and I've also been a judge pro tem. So I have the experience to be in the courtroom helping the people.
Thank you, Candidate Jones. And Candidate Erb for position 2, your closing statement, please.
Thank you very much. And thank you again to the entire team at City Club for putting on this program and helping educate the voters in our community about these important down ballot races. You know, Superior Court judges are incredibly important, and they make decisions every day that affect the lives of our friends and our neighbors here in Whatcom County. And I am really glad to bring my broad and deep experience to this race. I've been practicing law for over 15 years. I have handled each type of case that comes before Superior Court judges every day, whether that be criminal or family or civil law cases. I am truly independent of the local prosecutor's office and law enforcement community, and I'll bring that independence and fairness to the bench. And I have been vetted. You know, Candidate Nelson said that we hadn't gone through that process, but I was encouraged to apply for a gubernatorial appointment through the governor's office. And so I did sit down with 7 different state and local bar associations, and I did receive ratings of well qualified and qualified to be a judge, which speaks to my experience, my qualifications, my judicial temperament, my communication skills, and my ability to treat the people who come into the courtroom every day with the dignity and respect they deserve. And that's what I promise to do if you vote for me, James Erb, for Whatcom County Superior Court Judge in position 2. Thank you.
Thank you very much. And now, I'd like to thank our candidates for participating in the Bellingham City Club Forum today. We appreciate your support in helping the voters of Whatcom County cast an educated vote. Today's forum was the second of 3 forums that City Club is producing for this year's local election. Our first forum was for the 42nd Legislative District, positions 1 and 2, and our third forum will feature the candidates running for Commissioner of the Whatcom County Public Utility District. We would like to thank the City of Bellingham and BTV Bellingham for scheduling our forums on Comcast cable channels 321 HD and 10 SD, and CenturyLink channels 1040 HD and 40 SD. Online access to our forums is available on the City of Bellingham's YouTube channel. To find them, just visit youtube.com and search Bellingham City Club. Thank you, and remember to vote on November 3rd.